Good morning, councillors. Good morning, committee members, members of the media and the public. Thank you for the opportunity to speak with you. It's actually no longer morning. I prepared my remarks with a different idea of timing in mind. I'm happy to be here on behalf of the Canadian Civil Liberties Association, CCLA. We're a national, non-profit, non-governmental organization. I have just a few minutes. You've heard a lot, but I do want also to congratulate you on this protocol and explain why the recognition and protection of the rights of people who are trans and gender nonconforming are so important and required by law, and to recommend some key improvements. Although I will mention that some of my comments have already been transmitted to Councillor Johnson, and so you will have the opportunity to hear about them if we run out of time here. Because before I get into my prepared remarks, I did want to respond, as others have done, to some of the comments made by previous speakers that this committee heard earlier. So for the Canadian Civil Liberties Association, being a national organization that works for the rights and freedoms of all people, security of the person, violence and sexual violence, and violence against women and girls, whether they're trans or cis, is an important subject. So consistent with our practice, we engaged in rigorous research before we took a public position on the topics that are facing you today. And if there are councillors with any residual concerns who haven't yet had the opportunity to look for evidence, I would encourage you to do the same. And what we found, it's hard to find an absence of evidence, but we actually did, because despite the expressions of worry and speculations about feelings, what we found was no actual evidence of danger in washrooms and change rooms by trans people, or even in those situations where municipalities have created policies and protocols like this one, even where municipalities and police forces have gone looking for evidence of danger and of assaults. So I would reassure you that any concerns and speculations that have been expressed are not based in evidence. However, there is evidence, which you've heard about already, about actual violence experienced by trans people in society, in public spaces, and yes, indeed, in washrooms. One study, this is not about washrooms, but generally, one study found that 49% of trans students in schools have been sexually harassed in school within the past year. This was from a couple years ago. 37% of trans students have been physically harassed or assaulted because of their gender expression. 20% of trans Ontarians have been targets of physical or sexual assaults because they are trans. 34% of trans Ontarians have experienced verbal harassment or threats because they are trans. And we haven't even begun to get into the homicides and other terrible attacks. So if there is no evidence of violence against women and girls, including cis women, non-trans women in washrooms and change rooms, then perhaps it makes sense that some of the previous speakers spoke instead about awkwardness or discomfort at having possibly to look at various shapes and sizes of different bodies, although anybody who's been in a change room knows that that happens anyway. And I would add that not everybody feels that awkwardness and discomfort. We quickly get used to what's around us. But even if there were this hypothetical awkwardness, we would have to contrast that with the physical, real safety of the trans men and women who may want to use change rooms and washrooms in Hamilton's public spaces. Ethically, I think there is no question, and I'm happy to say that the law, constitutional law included, has looked at those kinds of balances. And again, I refer back to a previous speaker who said something about balances in constitutional law. In law, we would not place people's hypothetical feelings of discomfort about speculative situations over the real protections needed for the life and safety of actual people. So I think I have very little time left. Great. I'll mention very quickly that the civil liberties issues that are raised by this protocol fundamental human rights, as you've heard before, include the following from our Charter of Rights and Freedoms, a charter that wasn't, but I understand is being added to the protocol. Firstly, the right to equality and to human dignity, regardless of who we are, without fear of persecution by the state or the majority. The right to express ourselves politically, artistically, or otherwise, to be and to express our most authentic selves, a right that we all hold dear regardless of our gender identity. And of course, the right to life, liberty, and security of the person, the right to autonomy and to make fundamental life choices for ourselves, to use public space safely, and to be free from violence. All of that is inherent in the protocol that you have before you. I'm hopeful that the protocol, if implemented properly, will have positive practical outcomes so that city staff is properly educated and won't turn away another individual who simply needs to go, forgive me, and pee.
Thank you, Noah. You've reached, it's Noah?
It is.
Okay, Noah, you've reached your time.
Thank you.
We do have questions, however. Councillor Aidan Johnson.
Thank you. And through you, Madam Chair, Ms. Mendelsohn, Aviv, what is the Charter and why does it matter in this conversation?
Thank you, Councillor Johnson. The Canadian Charter of Rights and Freedoms is a part of Canada's Constitution. It is the super law of Canada. It prevails over other laws. The Canadian Charter of Rights and Freedoms includes some of the rights and freedoms that I mentioned: equality, life, liberty, security of the person, the right to expression. All of those rights are protected in the Charter, and if any public body, whether it's a legislature or a city council, try to pass a law or enforce a policy or to take an action that violated the Charter, the courts would find in favor of the protections in the Charter.
Thank you very much. And Madam Chair, I'm pleased to report something that you already know, which is that later on I will be moving an amendment to add the Charter of Rights and Freedoms as one of the grounds of law that Council recognizes as a base for the protocol. Ms. Mendelsohn, Aviv, through you, Madam Chair, I know you've had the opportunity to read the protocol. What comments would you make in terms of future improvements, given we have an annual review of the protocol?
Thank you. We have spoken in the past with yourself. We have passed on our comments and recommendations. But briefly, I would say that there are three basic issues. The biggest one is privacy. Privacy is also protected under the Charter and under other quasi-constitutional laws in Ontario. And the protocol, although it goes a long way to protecting individual privacy, a privacy that's particularly important in this context of which we are speaking, where people want to maintain privacy around their gender identity. We feel, and we have a great deal of expertise on privacy matters, that it could be strengthened and bolstered so that data, for example, shouldn't be collected unless it's for a very specific purpose, and once that purpose is no longer in play, it needs to be destroyed. There need to be strong protections around access and sharing of information. That was one of our main recommendations. Another one had to do with the inclusion of the Charter in the protocol. And the third one has to do with terminology, to understand that indeed, as somebody said earlier, everyone does have a gender identity. And so the protocol needs to clarify, I have a gender identity as a cis woman, and that was disclosed when you referred to me as Ms. Noah Mendelsohn Aviv. And so we need to do some thinking around what kind of language can go legally into a document like this one that is both accessible to staff but also legally correct.
Thank you very much. And Madam Chair, I've started a good conversation with our city solicitor about the right next steps in light of the CCLA feedback. And at a future date, I'll look forward to reporting on the fruits of that ongoing conversation. Thank you very much to the CCLA for speaking out.
Thank you.
Councillor Whitehead and then Councillor Green.
Thank you. Often some of the critics, and you were talking about harm, and there's no evidence, which I certainly respectfully appreciate and understand. But I think one former speaker identified it as the gender straw man argument, gender specific. It's not about the transgender and the harm. It's about whether or not the policy itself would lend itself to assist male gender predators in the context of the policy. So can you help me address that issue?
The committed feminist, that was the research that we engaged in. It was not about concerns that trans women would prey on other women in washrooms, but whether this was going to provide some space or license, or whether there would be an evidence of increased violence in washrooms and in change rooms because of policies like this one. And that was the evidence that we didn't find, and that was the evidence that other police forces and municipalities had been asked to produce when they were discussing protocols like this one, whether cis men would take advantage of it, waltz into a woman's washroom and say, hey, I can be here, and then turn around and assault a young woman there. And I think it probably makes sense that that wouldn't really happen, because if somebody was there to ask the question, they would probably be there to ensure that there is safety for people. I think the kinds of assaults that we're concerned about happen in spaces where there aren't people around to ask the questions.
So I appreciate the clarification on that. Thank you.
Thank you.
Councillor Green.
Thank you. And just for clarity, to clarify the clarity, through you, Madam Chair, in situations of predatory straight male violence, there are currently laws and law enforcement in place to deal with that, correct?
That is correct.
In theory.
It is correct that there continues to be violence against women and girls, cis and trans, in our community, and against boys and men, as we've heard. It is correct that we have police forces and security guards whose job it is to protect people, and I'm sure city staff do that work also on behalf of the young people that they care for. It's also correct that those kinds of activities are prohibited by law. And I think that all of that is carefully considered by this protocol.
And it's also correct that, unfortunately, given our current legal system, there are still many cases of gender violence that goes not just unreported, but dismissed when it does hit law enforcement. So that's, I'm sure, a conversation for another day, you know, given recent reports from the CBC and others. But my question to you, I'll ask you the same question that I asked the person who came before us as a constitutional expert. What positions would your association take should this fail here today? Is there remedy or recourse at higher levels of court of law to enforce what we have essentially put before us?
Well, the city, as I understand it, has already faced a human rights complaint and is obligated to create a protocol of some kind to address the fact that there was a failing in this case. I would imagine that if the city then failed to implement what it agreed to do, what it undertook to do as part of that settlement following a human rights complaint, that there would be further penalties pending. That wouldn't come from us. If there were a case that went forward, I imagine that CCLA would be interested in intervening and providing our advice as well to the court.
And could you just, for the public record today, state exactly who your organization is and what it does?
Sure. I am the director of the Equality Program for the Canadian Civil Liberties Association. We're a national, non-profit, non-governmental organization that works to protect the rights and freedoms of all people in Canada. We engage in various forms of advocacy and public engagement, and we also engage in litigation, usually, not always, sometimes we initiate litigation, but usually in the form of an intervener who comes to the court as a friend of the court to provide our expertise and advice to the judges who are hearing difficult constitutional and human rights issues.
Well, I certainly appreciate that clarity, and thank you very much for being here before us today.
Thank you.
Councillor Johnson.
Thank you. Just quickly, Madam Chair, I'd like to thank Councillor Green and Ms. Mendelsohn Aviv and Councillor Whitehead for clarifying a lot of the legal questions that pertain to the trans protocol. An argument that I make to do with the protocol that I think matters in this specific conversation is that the City of Hamilton, of course, has a legal obligation to respect transgender equality. And additionally, we need to think about our ethical obligation to respect transgender equality and the things that we need to do that may be above and beyond the baseline of our minimal legal obligation. So that's a very interesting conversation, and I'd like to thank Ms. Mendelsohn Aviv for helping us think about both the law and the ethics of this challenge. Thank you.
Thank you, Councillor. Thank you, Noah, for your presentation.